The Supreme Court heard oral arguments both for and against affirmative action last month. The two cases, Students for Fair Admissions, or SFFA, versus Harvard, and SFFA versus University of North Carolina, could reverse 40 years of precedent of race-conscious admissions to colleges and universities.
Affirmative action broadly refers to policies that favor individuals who have been subject to previous discrimination. In colleges and universities, it has often been used to diversify enrollment, granting admissions to minority students who previously had been denied access due to their race.
A landmark case for affirmative action came in 1978 when the Supreme Court considered Regents of the University of California versus Bakke. Alan Bakke, a white man, applied to the University of California Davis's medical school. His application was rejected because of the school's racial quota system. Out of 100 spots, 16 were reserved for racial minorities. Bakke sued the school, arguing that the racial quota system was unconstitutional and a violation of the Civil Rights Act of 1964.
The court agreed that UC Davis's quota did in fact violate the Constitution's Equal Protection Clause and the Civil Rights Act, but it also ruled that diversity in university admissions was a constitutionally permissible goal. Since then, schools have used race as one part of a holistic application process in admitting students. But this process has routinely provoked a pushback, often from white and Asian American students who say it is discriminatory.
SFFA, a nonprofit formed by conservative activist Edward Bloom, initially sued Harvard and UNC in 2014, alleging the schools illegally discriminate against Asian American and white applicants. The group argued that Asian American applicants are held to a higher academic standard than other students in Harvard's application process.
Like Bakke, SFFA said that the consideration of race in the admissions process violates the Constitution's Equal Protection Clause. The group is now asking the court to overturn the 2003 case of Bruter versus Bollinger. Harvard denies that its policy is discriminatory and has accused SFFA of seeking to upend decades of precedent that promote on-campus diversity. Meanwhile, in the UNC case, SFFA argues that the college is discriminating against white applicants.
The NAACP released an amicus brief earlier this year accusing SFFA of attempting to instill a revisionist interpretation of Brown v. Board of Education. Brown explained how the racial caste system, established through chattel slavery, demeans and subordinates Black people, and thus promised to secure their equality in our educational system and as citizens of our democracy, the NAACP wrote. To overturn the precedent of race-conscious admissions would contravene Brown's core principles and transform Brown from an indictment against racial apartheid into a tool that supports racial exclusion, prevents further advancement in the nation's progress towards racial integration, and deepens persistent inequalities in educational opportunities.
Currently, 9 states have prohibited the consideration of race in public university admissions. California, Florida, Washington, Arizona, Georgia, Michigan, Nebraska, New Hampshire, and Oklahoma are those states.